Last month, the Supreme Court ruled in favor of a website designer in the case of 303 Creative LLC versus Elenis. In a 6-3 decision, the justices ruled that the First Amendment prohibited the state of Colorado from forcing the designer to create message with which she disagrees. It is a landmark case that could have far-reaching implications. And here to talk with us about more on this is Jonathan Scruggs, Senior Counsel and Vice President of Litigation Strategy and Center for Conscious Initiatives with Alliance Defending Freedom. Jonathan, great to be with you today. As mentioned, the 303 Creative case truly was landmark. Tell us quickly about the significance of this ruling and how it could impact other cases.
Absolutely. It was a great win for free speech and the First Amendment because at its core, the Supreme Court said the government cannot force people to say things they don't believe. And that applies to all speakers, whether those who believe in marriage between a man and woman or those who disagree. It protects the LGBT artist. It protects the Muslim artists, the Jewish artists. Again, the bottom line is the government can't come in and force people to violate their core convictions and their conscience. And that's good for all Americans.
And Jonathan, I know the ADF is currently representing two clients whose cases are very similar to 303 Creative, Chelsea Nelson Photography versus Louisville Jefferson County Metro Government, and also Emily Carpenter Photography versus James. Tell us a little bit about those cases and how Lori Smith's case directly impacts them both.
Absolutely. Well, they're very similar cases, except these other cases you mentioned involve wedding photographers rather than a wedding website designer. But really, the principles are the exact same. In all these situations, both Chelsea and Emily serve all people regardless of who they are. There's just some messages they can't create for anyone. And so that's why it lines up exactly like the 303 Creative decision. And we're simply going to court and saying these cases are over. 303 decided these cases and set the rules. And it just goes to show how important this 303 Creative decision is. It's really protecting Americans right now, all across the country, from officials who are just seeking to silence them. They're seeking to coerce their conscience. So it really is a great victory that we're looking to bring forward all across the country to protect Americans.
Yeah, and what is the status of these cases right now, and what do you expect to happen?
Absolutely. In the Emily Carpenter case, that's before the Second Circuit Court of Appeals, which is in New York. We're waiting for a decision for that court. And then in Chelsea Nelson, that is before the Sixth Circuit Court of Appeals, which is based in Cincinnati. We actually have oral argument scheduled for next week at the end of July. And that'll be really one of our first opportunities to go into court and to make these arguments to say 303 is decisive. It should end this case. It should protect these people from government infringing their First Amendment freedoms.
And I'm curious, what kind of pushback did these women get for, kind of standing their ground when it comes to the First Amendment?
I mean, unfortunately, they are receiving threats and unfortunate attacks via email. Standing up for your freedoms sometimes is not popular, but they've also received a lot of positive feedback too. And that's a great thing because I think people understand, right? If we want freedom for ourselves, we've got to extend it to others. That includes those who we disagree with, whether it be about marriage or other topics. Again, we should be protecting not just Chelsea and Emily and Lori Smith, but we should be protecting the LGBT photographer, the atheist who doesn't want to be forced by their government to promote religion. The First Amendment and freedom of speech are big enough to protect all these speakers. And that's because the First Amendment protects the individual's right to choose what to say. It doesn't allow the government to come in and mandate particular orthodoxies.
We're going to continue to follow those cases. And on a different note, I know there is an independent pharmacy in North Dakota owned by Kevin Marsh, and a devout Catholic who operates his business in accordance with his Catholic faith and beliefs. Tell us about this case and also what's at stake here, Jonathan.
Sure. Well, I mean, 303 Creative involved speech. It didn't necessarily extend to free exercise of religion, but there are a lot of cases on that point too, the importance of free exercise, that really people should be able to enter into the business and operate consistent with their beliefs. That's also a fundamental freedom. So ADF looks to protect both the right of free speech and the right of free exercise. And we've done that successfully on behalf of not just web designers, but also those in the medical field. again, there's a way that people can operate consistent with their religious beliefs, their freedom of expression, and also comply with the Constitution, with other laws. There's a way to do that, and we're thankful that we've been successful in these court cases so far.
Well, Jonathan, thank you so much for your time today. We appreciate it. God bless you.
Thank you so much.